Good afternoon, class. My name is Sarang Haseeb, DY30229. I'm here along with my group mates Kasha, Jamshed, and Imran. Today's topic for discussion is on the case of Horne State versus Queensland, QCA 432, 11th August 1995. The main appellant, the plaintiff, is Veti Sonja, and she's actually not happy with the justification of the head listening to this case, head of Queensland. Okay, so what happens in this case is that the lady, which is actually 23 years old during the time of the appeal, and during the time of the actual incident, she was a 13-year-old girl studying in Apsley School. Um, actually, due to the normal regular activities of the school, this girl and her schoolmates were promised that they are gonna be provided with a safe and secure means of transportation from their school to the Coop Center, as you can see from the case, for regular school activities or any entertaining activities. And after being acknowledged to her mother that she's gonna be provided with a safe and secure means from the Coop Center from the school to the Coop Center, the school didn't perform their duty as they promised, so they didn't keep up to their commitments. So as far as we group mates have analyzed this case, there's a tort of negligence which involves duty of care, breach of duty of care, and there's a bit of contributory negligence because the plaintiff didn't had any choice because the school didn't provided the secure means of transportation, so she went with a friend riding on a bicycle, and it was clear that there's a contributory negligence because there must have been actually a school supervisor in assisting them in the transportation from school to the center, but she took for the bicycle from a friend and ride off, and she unfortunately came into an accident with a semi-trailer ran over her, and she caused injuries, severe injuries. And the rate at which the other side is that the rate which the court has appointed is like 75% damages to be bared by the by the state because of bearing the several injuries and the medical treatment. And but the plaintiff argues that the rate at which the commercial care was provided, that included the administrative cost, was varying from $7 to $8.50. But in actual assessment, the damages it was assessed by the judgment was just $5 per hour, and there was no amount allocated for future care for the actual incident that occurred in this case. So we believe there's a sum of compensation should be allocated for future care because of 3 hip replacements and 1 knee joint replacement between the age of 30 to 65, which is going to happen in future.
Hello everyone, my name is Katryzyna Bartos EUC3006. As my friend Sarang was explaining to you some history and the background of the case as well as the issues of the case, my part is to explain to you some rules according to the situation, and also I will explain to you the broad aspect of tort of negligence. So the tort of negligence is, for example, in a situation when one person owes duty of care to another one, negligence is doing or failing to do something what reasonable person would or wouldn't do it, which cause serious damages, injuries, or losses as a result. So let me prove the negligence in this case now. First one is a duty of care. As far as we understand with my group members, we think that school owes duty of care to the plaintiff, in this case was 13-year-old girl, because the school administration is responsible for appropriate and safe transportation means for children for any activities taking part from school premises, such as in this case from school to the tennis center. Second one is foreseeability. In this case, the school must have realized that if they had acknowledged the parents that they would provide secure transport, and later they don't keep with their promises, many girls could have been seriously injured or could have lost their lives or suffer from physical damages as our plaintiff. The third one is breach duty of care. The school failed to keep up with their commitments on providing safe transportation to the school children from school to the Cops tennis center. Lack of school supervision and attention to school children's care significantly adds up to the breach duty of care. Fourth one is damages. The plaintiff suffered from serious damages when had an accident on the Binns Road because of the school negligence. She had to go through medical treatment, and between 30 and 65 she needs 3 hip replacements and also 1 knee joint replacement. So the plaintiff is also entitled to future care compensation. And the last one is contributory negligence. In this case, our plaintiff is also guilty of the accident because it was clearly mentioned that on a Binns Road is always traffic and the road is busy. And it was very unsafe to ride a bicycle, especially for such.
Hello, welcome guys. We have just the case from the plaintiff side that the girl who she is being injured or wounded by a semi-truck driver while going from the school to the tennis court, and the facility was not provided by the schools, and the management was responsible for the carelessness and the negligence. So there is a question arise whether she, the appealing party, also responsible or contributed in the negligence or the carelessness of the damage. She got it. Yes, we got it. And point of investigations that when it was investigated, the bicycle brakes were not fully operational. It was just the blemished and the brakes were faulty. So here she got also an contribution for our carelessness, and when that is the outcome of our damage or an accident. So we see it. And we can also see it another point that the judge even don't know, like whether she knows about that the brakes were faulty or blemished, that she's still riding. So the judge also did not found any findings about that. But we can still that the girl is under 18, she don't know it. So even she can just jump from the road to footpath, even to just avoid herself, but she don't know in the rush, but she don't know in the crowds. So that's the important point. And we can also see that there is an particular objection for the when the amount for the compensations between the appealing party and the respondent. So there is also one contradictions, and the contradiction was they have not been paid under the market value when our brother and the sibling were just providing the care for her, the medical all services when it is being provided, and further the surgical things, and they have not been paid under the market value. So when it is totally decided, there was an when our mother just treated her, and as well as when our sibling treated her, so they have just the different rates under the market rate. So the judge have also decided to see these things, and they have to consider all the amount which their mothers and their siblings have paid for our medical situation, and also for the future for the future surgery which would be occurred after 30 years. So there we got. And if we see from the college side or from the school side, we also got one important point, that the school instructor, which must have to exercise the power, they have just did not exercise any power for the supervisions or to see what they boys and girls, what the students were doing. So it is not exercise the power. But from the other side, we can also see here that there is also an obligations and the considerations from the appealing party. So she must have to understand the obligations and the appealing party. So here we got the application of our assignment.
Thanks, Jamshed. My name is Imran Fida, and my student ID is ABNN 3038. As my group member already told you about the issue, rules, application of this case. Now I will summarize all these things. There's issue, rules, and application of this case. So the school organization and educator head has a lawful obligation regarding to the security of their students, or they have to really act upon on their on practical administration and smart direction. So their lawful brief is to avoid any potential risk and prepare for any dangers and any predictable threats. So the Queensland schools was accountable to the school girls who was harmed during the cycling from their schools to the tennis court. As the Queensland school had already guided their students to arrange arrangement their own facility from the school to the tennis court. He has already give a suggestion to that the bicycling was a best and satisfactory approach to do so. So the Supreme Court held and came to the conclusion that the school neglecting to administer the safety of their students between the movement between the school and the tennis court. Well, thank you for listening.